A copy of the slides that were presented to the owner by Bechtel on October 22nd, 2015.
Did you attend the October 22nd presentation by Bechtel?
I didn't attend in person. I attended by phone during part of it.
Why did you not attend in person?
By this point in the history of the project, the most important thing to me, and frankly to the owners, was what ultimately became the October 2015 amendment to the EPC contract. And that's what I was focused on. That's what I was spending my time on. And Bechtel's significance was greatly diminished, in my view, by this point. In fact, I flew up to Columbia that same day because I was making a presentation to the Santee Cooper board on the October 2015 amendment. And if it would have been easy to fly up earlier if the Bechtel presentation was still considered an important feature of the project. It was not.
Can you briefly describe what you recall about the substance of Bechtel's presentation on October 22nd, 2015?
The main portion that I remember relates to the schedule assessment. And I called in after the presentation began. I was not on what they call a webinar, so I didn't see these slides. I eventually got these slides in January of 2016, but I didn't see them at the time of the presentation. But I heard them going on about their schedule projection, and at that point I interrupted the flow and asked a series of questions about methodology.
Were you surprised to hear that Bechtel had provided new estimated completion dates?
I was surprised that they had undertaken that effort or that job, because it wasn't something I asked for or expected or was identified in their contract.
You said that you asked Bechtel questions about their methodology. What types of questions did you ask during their presentation about their scheduling methodology?
I asked the sort of questions that I would ask of any consultant brought in to assess a schedule on a project. I asked them pointed questions about their methodology. Because telling somebody a projected completion date doesn't really mean much to me unless I'm satisfied that there was a sound methodology used to arrive at it. Bechtel could pick dates, and they might be right or they might be wrong, but I can't know that or have any confidence in what they say unless I'm satisfied that the methodology they used was something that I considered to be sound. I've litigated those issues for years as to what is a sound methodology and what is not, so I had developed an opinion about that.
What did
This is the same issue we talked about earlier. I'm not objecting to Mr. Winnick talking about what he said during the meeting, but then he slips into explaining, offering opinions about his concerns, and that's when he crosses the line into expert opinion testimony, and that's the reason I rise to object.
Yeah, Mr. Chairman, if I may, Mr. Elby, I believe this is a little bit different from this description of what was going on before. It appears to me that Mr. Winnick can explain his concerns and what motivated his thinking in this situation. I would recommend overruling this objection, Mr. Chairman. I understand your position.
And I understand your ruling or your advice to the chair, but it's a slippery slope. Our earlier witness talked about a slippery slope. It would not be difficult for Mr. Winnick to simply go right into offering opinion testimony. Thank you.
Thank you. We're going to overrule, but we encourage you not to slippery slope into opinion.
Yes, I've been following the objections carefully, and I think I understand where the panels come down on that, and I'll try to take care to confine myself within within your ruling.
What did Bechtel tell you that their scheduling methodology was?
Well, they told me what they couldn't do because of limitations on access.
Let's start there. What did they tell you that they could not do?
Well, the one thing that I remember with some clarity was that Bechtel said that they attempted to download the contractor's CPM schedule. That CPM schedule was huge, as electronic documents go. And Bechtel told me that they were not able to download the entire schedule, that they let it run for a certain number of hours and then interrupted it, and that concerned me. That meant to me, well, in fact, they then explained that they were not offering opinions on any flaws in the contractor's schedule. They were not pointing out things that they would have done differently. They weren't pointing out things that were in the schedule that cloaked problems on the job. And that's really one of the main things that I wanted. So that was disappointing. Two, they told me that they had based a projection on on bulk commodities. Now, in this context, what that means is you've got earthwork. On the civil side, you've got concrete and rebar. On the mechanical side, it's mainly piping. And on the electrical side, it's conduit and cable. So you know that you have a certain number of feet of cable, certain number of linear feet of piping, certain cubic yards of concrete, and so forth and so on. So they used that as their basis for developing their schedule. But they told me that they didn't know from Westinghouse and CB&I how much had been installed by area. That is, Westinghouse and CB&I shared the total quantities of those items that I mentioned and shared the amount in place. But they didn't. But Westinghouse, CB&I didn't say, well, we've got so many cubic yards in the turbine building and so many cubic yards in the auxiliary building and so many lineal feet of piping in the shield building and so forth and so on. They didn't break it down. But nonetheless, Bechtel went forward with their analysis. And then what did they do? Well, they used these quantities, these bulk quantities for earthwork, concrete, piping, and cable and conduit, and broke it down by areas. And then they didn't have the units that the contractor had actually achieved on the project to date. And they didn't have, by this time, the contractor was working on mitigation efforts. And as I say, this is the time when they're planning on bringing in Fluor, they're planning on buying out CB&I, so forth and so on. So Bechtel knew that there were mitigation measures afoot and knew that there were projected different productivities, but Bechtel didn't have those either. So Bechtel used what they called their historic data. Well, there hasn't been a new power plant begun since 1979. So anybody who says that they have extensive experience in new construction is puffing, or they've been overseas a lot. I didn't think that using historic data in that context was the methodology I was looking for. And the only reason I'm mentioning is because that's what I advised the client. That was my conclusion, and that's what I advised the client. I'm not offering that opinion for you to evaluate that opinion independently, but I hope that it's interesting to you to know what I was advising the client, and that's what I told them.
If you look at page 25 of the document behind tab 7, that is this PowerPoint presentation, the last bullet point says, a more robust approach is needed prior to finalization of any changes to the baseline target schedule. do you recall Bechtel saying words to that effect in the October 22nd, 2015?
I do, and they also use the term a level 2 schedule.
What does that mean?
Well, a level schedules are categorized by levels, and that's been around in the industry for a long time, with 0 being basically just start and finish, and then more and more detail as you move down from that point to 4 or 5. Eventually, there was an organization that I think people recognize as being authoritative that published definitions of those levels. But in any case, a level 2 schedule really doesn't say much more. It's not much more than a bar chart. It gives you start dates and finish dates. And Bechtel was, you can see that on this slide it says preliminary results. Bechtel was stressing the fact that this was all preliminary. And they specifically said that they recognized that a level 2 schedule couldn't be relied on to develop a baseline target schedule. Now, what's a baseline target schedule? That's the baseline schedule that we would have with the contractor. And that was very important to me. Because if they had data, if they were coming forward and said, we have data that you should use to adjust the baseline, that affects that October amendment. Because we're making a deal with Westinghouse based on certain dates that Westinghouse has provided that are different from the Bechtel dates. If Bechtel said that this is not preliminary, this is final, this is robust enough, and we're telling you that you need to change your baseline target schedule, then what are we going to tell the contractor? We can't hide that information from the contractor. So either it's adequate and developed enough, and beyond the preliminary stage, and this can be used to change the baseline schedule, in which case we need to reconsider how we're dealing with the contract, or it's not. And that, again, was what I was telling the client.
All right, so let's go to that. And I think that's an important point. If you look at, before we do that, Mr. Chairman, I'd move as the next hearing exhibit the document behind tab number 7.
Okay, the tab 7 document will be entered as exhibit number 112.
So let's look, Mr. Winnick, at the document behind tab 8, and you've mentioned to the commissioners that you provided advice to the clients about your views of the Bechtel assessment. Can you identify for the commission what the document behind tab number 8 is?
Yes, that's an email that I wrote on November 12th, so obviously after the oral presentation and the slides, to Ron Lindsay, who was general counsel for SCANA at the time, and with a copy to L. Bynum, and I wrote it just to those two people because Ron Lindsay wanted me to put in writing some of these orally expressed concerns I had about the Bechtel assessment.
I want to start at the 5th paragraph. This kind of picks up on what you were just talking about on the level 2 schedule. You say that, more important, Bechtel described its schedule as a level 2 schedule. That is a reference to a commonly used system for classifying project schedules based on the amount of detail involved, with level 0 being the least detailed and level 4 being the most detailed. Do you see that?
I do.
So can you explain what to the commission what the advice you were giving to the client contemporaneously, that is, as of November 12, 2015 was?
Yes. So in the second paragraph, I mentioned that if we pull out the second paragraph of the email, at the end I say that as part of the preview, Bechtel explained...
Make sure you get that mic in front of you. You're reading down.
As part of the preview, Bechtel explained its methodology for analyzing the project schedule. Well, that was done because I asked a series of pointed questions. They admitted during the preview, Bechtel admitted during the preview, that it did not base its analysis on the current project schedule being used by the consortium. It explained that the consortium schedule was too large and complex for Bechtel to understand in the limited time that Bechtel had to perform its analysis, 7 weeks. Emphasizing that point, Bechtel stated that it was unable even to download the electronic version of the consortium schedule because of the time it would take to download a schedule of that size. And then if we go to the next paragraph, now I apologize for reading to you. I don't like it when other people do it, but I think it's there's no better reflection of what my thinking was and what my advice was to the client than the actual words. So I'd say instead of relying on the consortium schedule, Bechtel prepared a simplified high-level schedule. The simplified schedule was based on their prior experience and so forth and so on. That fact alone means that Bechtel's preliminary analysis is of limited use. We have no reason to believe that Bechtel's conclusions have equal or superior merit when compared with the consortium's conclusions, which reflect the consortium's years on the project. And then I go into the level discussion. And what I'm doing there is quoting from the American Association of, it actually says cost engineering there, but it's cost engineers, AAC International, and that's a body that publishes recommended practices for people who are in the construction industry, and I recognize it, and other people have recognized it as being authoritative. So rather than simply rely on my own judgment and experience about what Bechtel was up to, I wanted the client to have the benefit of an authoritative treatise on scheduling. And this in particular comes from recommended practice number 29 of AACE. And they describe these levels. Level 0, as I said, is basically just start and finish. Level 1 is the next step down. And they say to differentiate between program and project, schedules, a level A schedule of a program schedule would be a combination of level 0 schedules for each component of the project. So you break the components you break the project down into various components, but then you still have just start and finish dates. Then level 2 might break down the areas of the project into different systems. As it says there, it might break it down into water, electrical, gas, storm drainage, and so forth. Milestones are normally included. And then level 3, if we could pull that out, and this is really the point of my quoting from AEC. The first level that a meaningful critical path network can be displayed and the CPM schedule can be used to monitor and control the overall project work. Level 3 is a good level for the overall project control schedule since it is neither too summarized nor too detailed. Now, so to me, a level 2 schedule can't be used to do the types of projections that that Bechtel had done with any confidence. And a more robust schedule, what I understood them to say by a more robust schedule would be needed in order to set new dates, would be at least a level 3 schedule.
So, and you were saying, you go on to say in the next to last paragraph on the next to last page of this document, that based on Bechtel's statement that its schedule is level 2, its schedule is insufficiently detailed to enable Bechtel to provide a meaningful critical path analysis for making projections about project completion. Why did you say that?
Well, I don't want to repeat all the answers that I've given, but I had judged based on the answers that they gave me during the oral presentation, I judged that their schedule was inadequate for the purpose of setting new baselines, and they said that during their presentation. It was inadequate, and they needed a more robust method. So I was not advising the client that, you need to change your thinking about when the completion date is. And I wasn't advising the client, you need to tell the contractor that before he signs up for hundreds of millions of dollars of increased liquidated damages, that the dates that he's selected are wrong. No, I was advising the client that we should stick with Westinghouse's projection because they were putting skin in the game. They were willing to stand behind their own projections to the tune of hundreds of millions of dollars in liquidated damages for late completion, as opposed to a schedule that wasn't robust enough for that purpose.
Were you familiar at the time with the consortium's scheduling methodology?
Yes, they used what was then the latest version of the Primavera software. It's called P6, and that enables you to identify activities in a project. You establish the duration for that activity, days, weeks, months. You establish the relationship between that activity and other activities. Is it a predecessor, meaning you have to finish this before you start that? Or is it a successor, meaning you have to finish something else before you start that? And are there lags involved? And it's an algorithm that the software manages. And these schedules are enormously complex, of course, especially on a project of this size. If that schedule was something that Westinghouse was willing to stand behind, and Bechtel was telling us that their schedule wasn't robust enough to adjust dates, I was telling the client, stick with the Westinghouse dates. And then I go on to talk about the anticipation of litigation. Having retained Bechtel to aid in preparation for anticipation of litigation, I find Bechtel's current preliminary analysis to be unusable for that purpose. Now, I know who Bechtel is, and certainly they have a lot of people among their 50,000 employees who are capable of doing a lot of different things related to construction. And I wanted to make that clear as well. I said, this does not mean that Bechtel's personnel do not have the qualifications necessary to provide meaningful information. It simply means that the analysis is not sufficiently mature to provide meaningful insights into the schedule or the anticipated completion date. Preliminary conclusions often have this shortcoming.
You mentioned to the commission a minute ago that you were busy working on the 2015 EPC amendment contemporaneously around the same time frame as the Bechtel assessment report was made. And you suggested that the 2015 amendment mooted many of the issues that Bechtel had identified. Can you elaborate for the commission on that?
Yes. There were a number of comments that Bechtel made about the project that were mooted by the October 2015 amendment. For example, it was obvious to Bechtel, as it was obvious to the owner at the time, that Westinghouse and CB&I were no longer friends. There were disputes between them. We never had clarity as to what the commercial arrangement was between the parties, but we knew that there were disputes. Under the October 2015 amendment, Westinghouse was purchasing the stock of the CB&I company, and CB&I was leaving. So there would be no opportunity for friction between two entities because now it would effectively be one entity. CB&I was exiting the project, and Westinghouse was taking it over 100%. There were also concerns about CB&I's ability on the project. CB&I was not a nuclear contractor in general. That was not their history or their experience. These days, they do a lot of liquid natural gas work in the Caribbean and in and around Australia, but they weren't really people who worked on site on nuclear projects. They did work as vendors. They do tank work, but and the plan was to bring in Fluor to replace CB&I or take over some of the functions that CB&I had been performing, but Fluor would be a subcontractor to Westinghouse. Fluor had built Unit 1, and Fluor had roots in South Carolina, and they have a major office here, and a lot of people were familiar with Fluor. So there was a sense that CB&I's problems would be overcome with Fluor. So there were really quite a number of issues that were being resolved. In addition, the tension between the owner and the contractor we thought would be substantially reduced because we were resolving about $250 million worth of claims in the October amendment. And then finally,
I'm sorry, go ahead.
And then finally, and in some ways most important, we the owners had the ability to exercise the fixed price option. Now, why was that important? One of the issues that Bechtel identified in October was an issue that, of course, we were familiar with, but they didn't, they did what they did. But one of the issues they identified was that the contract between the owner and the contractor didn't protect the owner sufficiently. And what was that a reference to, as I understood it? It was a reference to the fact that the owner had great exposure because a large portion of the work, most of the field labor work, was being done on a cost-plus basis. It was under the target price component of the contract. There were 4 components: fixed price, firm price, target price, and T&M. T&M was a small amount. Fixed price and firm price work, the only difference was one of them could escalate. But that was mainly for equipment, and much of that equipment was pre-purchased. So there wasn't a big cost risk for the owner for those 3 components. But the target price, that's where there was a huge risk. And there was really not incentive for the contractor to be efficient with that because it was cost plus. Of course, they were paying the cost to the workers, but they were getting the plus. So if we convert that to a lump sum agreement, which was one of the options that we had under the amendment and which was eventually exercised, now all of that was to Westinghouse's account. I'm going to stop saying Westinghouse and CB&I because CB&I's gone down the road. So it was now all up to Westinghouse to perform to a fixed price. And so again, that complaint or that observation by Bechtel was mooted by the October amendment.
Right. So if the issues between the consortium and the owners were resolved or mooted by the 2015 EPC amendment, was it necessary at that point to maintain privilege over the Bechtel assessment?
We continued to anticipate disputes. In fact, one of the things that we did in the October amendment was that we agreed to impanel a dispute review board. What we didn't want to do was duplicate the experience of the Vogel plant and become embroiled in litigation during the project, distracting everybody's attention and draining resources. So we impaneled a dispute review board to provide decisions on everyday construction claims as they arose, and those decisions would not be final unless the parties deemed them to be, but they would be provisional and then could be revisited at the end of the project, at the time of substantial completion. But the concern about litigation, there may have been a brief moment when I was less concerned about it because we just resolved a bunch of claims. But very quickly after that, and when we start thinking about the dispute review board and impaneling the board, selecting people to serve on that board, then I began again thinking about that courthouse in Lower Manhattan and about a possible claim involving hundreds of millions of dollars if they were late, as well as other types of claims. So yes, I continued to be focused on the possibility of litigation. Frankly, I view that as one of my principal purposes of being engaged, was to keep an eye on today and keep an eye on the future. And the future in this context means possibility of future litigation.
Mr. Chairman, I move that the document behind tab 8 be marked and entered into the record as the next hearing exhibit.
It will be entered as Exhibit 113.
Did you have a hand, Mr. Winnick, in negotiating and drafting the 2015 EPC amendment?
I did. There's probably not a paragraph and perhaps not even a sentence that I didn't contribute to.
Turn, if you would, to tab 9 in your notebook.
Okay.
Is the document behind tab number 9 the October 2015 EPC amendment?
It is.
Mr. Chairman, I move that the EPC amendment behind tab 9 be entered into the record as the next hearing exhibit.
It will be entered as Exhibit number 114.
Now, I don't, and I know the commission doesn't want you to read chapter and verse this document. Can you summarize for the commission what you view as the key provisions of the 2015 amendment?
Yes, I'd be happy to. I've already alluded to the resolution of claims. If you're reading along, you can see on page 2, paragraph 3, there is a listing of claims. It initially says that they're resolved for $300,000, but then there was a credit back of $50,000. So the net value of these claims was $250 million. And there are itemized claims there, A through H, but then at the end of that itemization, it says that basically this resolves all claims up through the present that the parties are aware of. So we start out with a clean slate. Now, another thing that happened, of course, is that Westinghouse, and this agreement doesn't become effective until some other things happen, that Westinghouse is buying the stock of the CB&I subsidiary, Stone & Webster. We also understood that Fluor was being brought in. We understood that Toshiba was going to back up the EPC agreement with an increase in their parent guarantee. There was going to be a release of CB&I of all responsibility for the claim. We impaneled the dispute review board, or agreed to impanel the board, which we ultimately did do. We agreed that its decisions would be final for the purposes of putting the matter aside until substantial completion, and then they could be revisited later. It allowed for an option to establish a fixed price for the contract, and thereby eliminating the prior regime of the 4 components: fixed firm, target, and T&M.
Did you view the 2015 amendment as a positive event for the project?
I did. I thought it was positive all the way around. I thought it was positive for the contractor. I thought it was positive for the owner. I'm actually quite proud of the role that I played in that, and of the role that the owner representative played in getting that done. This is the way business disputes are ideally decided, by agreements like this, rather than dragging them into court and doing all that.
You had mentioned the fixed price option as being part of the amendment. Did the owners eventually elect that option?
They did.
Do you have an opinion on whether the fixed price option was the best option for the owners at the time?
I do.
What is it?
I felt it was by far the best option, and I did a great deal of investigation and work before arriving at that opinion.
Did you consider at the time that the owners elected the fixed price option that Westinghouse might be financially unable to finish the project?
No. That never occurred to me for really quite a variety of reasons. One is that I considered both Westinghouse and Toshiba at the time to be solid organizations, household names that had been around for my entire life and would be around for a long time after I was wrong. Let's make that clear. But moreover, the price when negotiated was based upon a negotiation of a projected cost before the fixed price issue was introduced, and then there was an effort to determine whether Westinghouse would in fact go with fixed price, and it was agreed that they would for an additional $500 million over and above what they were projecting to complete. So, and that's what induced them to agree to give the fixed price option. So from their perspective, they thought they could do it profitably. And in fact, that $500 million would address any contingency beyond what they were projecting with their own costs. Now, I thought, based upon projections done at my request, I thought Westinghouse was overly optimistic with respect to their costs. Otherwise, I wouldn't have recommended the fixed price option. We did some sensitivity analyses and determined that under almost any scenario, the exposure of the owner would be greater under the prior regime than under the fixed price regime. So I recommended that.
Are you aware of whether Westinghouse provided the owners any assurances about finishing the project?
Well, they did. It was. Do you want to know what those were?
Yeah, please.
I'm trying to stay within the confines of the ruling.
Thank you.
So the owner made clear in meetings with the contractor made clear in meetings with the owner that Westinghouse viewed these plants as something that they could probably build profitably, but more important, they would be creating a market for their refueling business, which was hugely profitable. And they, of course, they wanted to use this plant as the model for persuading other people to build plants. They were looking at opportunities in the UK and in India. Those I remember, perhaps others.
Were you actually present when the president of Westinghouse made those representations under oath in a proceeding?
I think you're referring to Jeff Benjamin, and he was executive vice president for international construction for Westinghouse.
Okay. And so was there a DRB proceeding in 2016 between the owners and Westinghouse?
There was.
And were you present in those proceedings?
I was. I was lead counsel for the owners in that DRB proceeding.
Do you recall a representative from Westinghouse making assurances about Westinghouse's commitment to finish the project in that DRB proceeding?
I do. It was relevant in that proceeding, and it was Jeff Benjamin who made those statements under oath in the DRB proceeding.
If you turn to tab 10, I'd like to just show you an excerpt from the transcript of the DRB proceeding and ask you to direct your attention to page 472, starting at line 17. And if you would, just read for the commission what Mr. Benjamin said under oath.
If we could start with page 472 and pull out that answer that's highlighted. Thank you. And so he's talking about the exposure that Westinghouse signed up for under the October 2015 amendment, and the maximum exposure in case of the fixed price option. There was a different exposure if we didn't do that, but under the fixed price option was $338 million per unit, so $676 million exposure for Westinghouse if they couldn't meet their own dates. And he said that's a little less than a year of operating profit profit for the entire company. But then he goes on to explain the business model of Westinghouse. So if we could pull out, there we go. So that's a substantial bet we're making. And he says, we hear of concerns that Westinghouse will walk away from a project. First of all, we have no history of doing that. Secondly, we know that the successful completion of these projects is essential to our future at Westinghouse. We build these plants. Then he goes on and talks about the business model, and this is, I remembered this clearly because this matters. You know, this is, as I say, this is one level below Danny Roderick, who was the president of Westinghouse at the time. But he was, Mr. Benjamin was the face of Westinghouse for most of us on the owner side. And he's saying, first of all, you know, the way our business model is, the real value we extract from building plants is not in the construction of these plants. So any notion that we layer a lot of profit in the construction of these plants is just simply not true. We're in it for the 60-year opportunity to service these plants and to refuel these plants and to provide the fuel to these plants. That's our business model. Westinghouse is a 100% nuclear company, so the idea that we would walk away from a marquee product, frankly, is nonsense.
Mr. Benjamin was under oath when he made those comments, was he not?
He was.
Mr. Chairman, I'd move that the excerpts from the DRB proceeding behind tab 10 be marked as the next hearing exhibit and entered into the record.
They will be entered as exhibit number 115.
I want to shift back to the Bechtel assessment, Mr. Winnick. So just to reorient ourselves, they presented their findings in October around the time of the EPC amendment. Did Bechtel memorialize those preliminary findings into a written report?
They did. Initially, it was a draft report.
And when did you first receive a draft report?
Early November, first part of November.
What did you do when you received that draft?
Well, I read through it, and then I followed what is my normal practice. That is, my normal practice in receiving a draft report from a consultant is to review it for a lot of aspects. I review it for readability, because not all of our engineers are as gifted with the English language as some of our lawyers. But I also review it for content. I don't think that in my entire career I've ever asked a consultant to change an opinion. Frankly, consultants who are willing to do that, I don't want on my team from the get-go. So I don't ask them to change opinions, but sometimes I might ask them to address additional things. I might ask them to consider additional points, and I might ask them to delete things that I didn't want them to address at all. Not change opinions, but to provide something less than what they had initially put together. Often when I retain consultants, they're on their own. That is, I'd sign them up, they then meet with project personnel, gather the material they think is necessary, then send me the draft report. So I'm not looking over their shoulder through this whole analysis period. So when I get the draft report, that's often the first time I know what they're up to. And so that's been my practice, and I think that's the standard among lawyers.
So when you received the Bechtel report, you reviewed the draft report in November. You reviewed it and you edited it. What is your understanding of what the federal rules of civil procedure provide as to the permissibility or propriety of a lawyer participating in the editing of or communicating with an expert witness about their draft reports?
Well, this is an issue that is important to me, and I really want to be as clear as I can be to this panel.
Stay in front of that microphone. We got people can't hear you in the back.
Yeah, sorry. So in 2010, there was an amendment to the federal rules concerning these issues. Prior to that time, it was unclear what the status was of draft reports. And I remember being involved in litigation where you'd try to get all the drafts and you'd try to identify by page or paragraph every little change from draft to draft to draft. And that's what half of the deposition of the consultant would entail. But other courts would say, no, you can't do that. That's a privileged communication. It's work product. So it was unclear and varied from district to district in the federal system. But then in 2010, it was clarified, and it was made crystal clear that those drafts were privileged. And I think that was done in recognition that when a lawyer retains a consultant and then presents that consultant in a trial, that the lawyer is sponsoring that evidence. So the lawyer is going to be held to sponsor the evidence in the final report, but all of the history of how you got there was going to be considered privileged.
So
and that was a change in my world, I'll tell you, because that made it very clear to lawyers that they were free to do that, and that those issues would not be addressed through the evidence.
All right, so just to clarify the point and to emphasize it, and so that the commission doesn't have to take your word for it, although I'm sure they would, let's look at tab 11, which is a copy of the relevant portions of Rule 26 of the Federal Rules of Civil Procedure, and I want to direct your attention to Rule 26B4B and 26B4C, so that the commission can see the language that you're referring to, and if you would just walk them through what you're talking about.
Yes. Now this is language that was clarified.
Mr. Chairman, I got a couple objections here. First is relevance. Second is now we're opining on the law. The Supreme Court says we can't do that. In the line of John Freeman cases, especially, our Supreme Court has made clear this line of questioning, even if he was an expert witness, would be improper. So I'm going to object on relevance and the fact that this has been barred by our Supreme Court.
Can I explain the relevance? The relevance is there have been questions and there have been serious accusations made about the propriety of Mr. Winnick making edits to the Bechtel report. And the language of Rule 26 provides an explanation of the legal basis upon which that conduct occurred. So it's highly relevant. He's not offering an opinion on the meaning of the rule. He's simply explaining what the rule says so that you understand to explain his conduct that has been challenged in very severe ways by the Office of Regulatory Staff.
Okay. Yeah, I want to hear it overruled.
As you can see on the screen,
Stay in front of that mic.
as you can see on the screen, the two relevant sections are B and C. Section B says, quote, trial preparation protection.
Counsel, just direct us to what page he's referring to in the link.
Sure, it's page 40.
Section B says trial preparation protection for draft reports or disclosures. There's a reference to Rule 26B3A and B, which relates to certain privileges, and it goes on, quote, protect drafts of any report or disclosure required under Rule 26A2, regardless of the form in which the draft is recorded. And then Section C says trial preparation protection for communications between a party's attorney and expert witnesses. Rules 26B3A and B protect communications between the party's attorney and any witness required to provide a report under Rule 26A2B, regardless of the form of the communications, and then there are certain exceptions.
So, is it your understanding that under Rule 26, the common practice would be for an attorney to communicate with the expert witness about the report and have the ability to make edits and changes to the report.
Mr. Commissioner, I need to object again on relevance grounds. The agreement regarding owner's project assessment introduced earlier by Mr. Balzer clearly states that Bechtel is a non-testifying expert provided by the Federal Rules of Civil Procedure 26B4D. So this entire inquiry about what is allowed under the federal rules and whether Mr. Winnick could in fact edit the report under the federal rules are irrelevant by the own document put in by Mr. Balzer earlier today. It's also misleading, and he's just frankly testifying as an expert.
Okay, after talking with Mr. Butler, we do think he can talk about his interpretation of the rule, so we're going to overrule. And
So, I'm sorry, the question that was pending that was objected to, Mr. Winnick, was what? Do you recall? Because I don't.
The question was whether it is my practice and the practice of lawyers, to my knowledge, to engage in editing draft reports. And my answer to that question is yes, it is my practice, and it's my understanding that that's the practice of other lawyers, not just construction lawyers, but lawyers generally practicing in the federal courts to engage in a review of expert reports and editing of expert reports, with the understanding that they are sponsoring the content of that report when the report is presented in evidence at a trial. And I also understand that a lot of state rules have followed the federal rules on this issue. But this was the relevant rule to me because, again, we're looking at the Southern District.
Mr. Chairman, I ask that the copy of Rule 26 of the Federal Rules of Civil Procedure behind tab 11 be marked as the next hearing exhibit.
it will be entered as Exhibit 116.
Now, what edits did you make to the draft report that you received in November from Bechtel?
I didn't ask Bechtel to change any language. What I did ask Bechtel to do was delete certain items. There were certain comments that they made about the owner management team that I had not asked them to do, and that I didn't think was necessary in the report. And I also asked them to delete the section containing their schedule analysis, which they said was not robust enough to adjust the dates.
Why specifically did you want to remove the schedule and the forecasted completion dates from the draft report?
Well, this goes to what issues I anticipated would be litigated in the Southern District of New York if we went to litigation. I anticipated that there would be the normal issues as to the scope of the project, that is, changes and the like. But I also anticipated that the time of completion could be an issue, that there could be claims by the owner against the contractor for the liquidated damages of the $676 million, and claims from the contractor against the owner for delay costs. I was concerned that a report by Bechtel would suggest to the contractor that they could use that report to avoid the binding nature of the liquidated damages clause on grounds of bad faith, superior knowledge, those kinds of arguments. And believe me, when hundreds of millions of dollars are in dispute, those arguments are presented with vigor. And so, having decided, made my own decision and recommended to the client that they act on that decision concerning the preliminary nature of the Bechtel report with inadequate supporting material and a methodology that I couldn't endorse. I felt that should not be in that report.
Did anyone from SCE&G instruct you on what to edit from the draft report?
No, this was all mine. So if anybody wants to criticize anybody for deleting sections of the report, then criticize me. I stand by that decision. I thought it was the right decision then, and frankly, in hindsight, I think that was the right decision based upon what I knew and what I was projecting, but that was my decision.
Do you have any discussions with the owners about whether to have Bechtel memorialize their draft report in a final report?
Yes.
Were you in favor of having a final report?
I wasn't. I didn't see the point of it.
Why not?
But we had just resolved a large number of issues. I learned what I needed to learn from the Bechtel report in terms of understanding those aspects of the project where they gave me some insight. So I didn't need another version of that report. I had the draft. I had their viewpoints. And, we've been talking about the schedule aspect, but the Bechtel draft report looked at 5 other issues, and some of those issues were helpful to me. They looked at project management. They looked at that's 1. Status of engineering, that's 2. They looked at procurement and inventory control, that's 3. They looked at project controls, meaning what types of controls do you have on the project to manage things, that's 4. And they looked at startup and commissioning. And I'll tell you that my eyes were opened as to some of those issues. Now, some of the owner personnel said they knew of some or all of those issues, but I didn't know of all those issues. So I did learn something from their report on those 5 other areas that ultimately were presented in a separate project assessment report. But I didn't see any point in having a final prepared.
Let me direct your attention to the document behind tab number 12 in your notebook, Mr. Winnick. Do you recognize this document?
I do.
Is this an email exchange between you and Mr. Lonnie Carter and others November 18th, 2015?
Yes.
Before we get into the substance of that, Mr. Chairman, I'd move the email exchange behind tab 12 be entered into the record as the next hearing exhibit.
It will be entered as exhibit number 117.
Okay, so to orient ourselves, we're now at November 18th, 2015. Can you describe for the commission the advice that you're providing to Mr. Lonnie Carter in your email?
Yes, it summarizes some of the points that I've addressed this morning about how certain aspects of the report were mooted. For instance, the relationship between Westinghouse and CB&I's performance and the original terms of the EPC agreement, which were modified in October. So those points were now obsolete. I also said that we've resolved what was now $250 million worth of claims. I was less concerned about litigation in November. It didn't take me long to change my focus, but at least in November, we were all feeling pretty good about the October amendment and hoped that there might be smooth sailing. So I just saw no reason to do it, to put it in form, in any other form. And so that's why I wrote Lonnie.
Was a decision eventually made to have Bechtel issue a final written report?
It was.
Do you recall who made that decision?
What I recall, yes, I do.
What do you recall about that?
What I recall is that Bechtel wanted to receive their last payment under the $1 million lump sum. And they wrote me and said, well, we consider what we've already done to be our final work, and therefore we want to bill you. And I said, well, let me check. And so I checked with senior executives at the owners. And specifically, I remember discussing this with Kevin Marsh and Lonnie Carter, and they said, no, we want the report. We want to go from the draft report to a final report.
Let's, Mr. Chairman, I'd move that the email exchange behind tab 12 be marked as next hearing exhibit and entered into the record.
We just entered that. That was 117.
Thank you. Okay, let's turn to the next tab in your notebook, Mr. Winnick. Do you recognize the document behind tab 13?
I do.
What is this?
This is the project assessment report. It's dated February 5th, 2016. In November, I received a report that was marked draft. You'll notice that this is not marked draft, so this is the final form of the project assessment report.
And if you flip through that, does this contain a schedule assessment?
It does not.
Turn with me, if you would, to tab 14. Do you recognize the document behind tab number 14?
Yes, I do.
What is that?
That is a schedule assessment report. Again, this is in final form, also dated February 5th, 2016.
Who made the ultimate decision to split the schedule assessment report into a separate report?
I did.
Why did you decide to do that?
The initial thought that I had was that we would have a single report, but we would delete certain components, as I mentioned earlier. We could delete the schedule reference, delete some of the criticisms of the owner. I thought those were, well, I thought they were half-baked. I'm just talking about what motivated me at the time. But in discussions with Bechtel's in-house counsel, they wanted to go another way, so they said, well, how about if we, I don't know exactly where the idea of splitting the report came from, but the end result was that we agreed to split the report with the schedule assessment being in one report and the rest of the project assessment being in the other. That is those 5 items I mentioned before.
Now, you had mentioned earlier in your discussion about the methodology used by Westinghouse, that they relied on commodities and similar issues to develop the schedule. Can you take a look at the document behind tab 14, the schedule assessment report, and specifically look at the summary schedule that is attached, at least the 4 pages of bar chart, and explain to the commission what you were talking about in terms of the commodity issue?
I can and I will. I just want to note for the record that I think you misspoke. You said that Westinghouse did. In fact, we're talking about Bechtel.
Sorry, you're correct, and I am referring to the Bechtel assessment, not to the Westinghouse assessment. Thank you.
So if we turn to page 10 of the document, I think it's going to be PDF
Page 10, stay in front of that mic so we can all, so everybody can hear.
which I think is going to be PDF page 30. Oh, there we are.
Just to be clear, there are 9 pages of text in the report, and what you're referring to is page 10 is a document that has in the top right-hand corner a legend that says page 1 of 6. Is that right?
That's right. And this, I wrote my email to Ron Lindsay, critical of the Bechtel schedule assessment, based upon what I heard during the October 22nd oral presentation. I didn't have the benefit of the draft report at that time, but when I subsequently got it, and this same section was in that report, then it really confirmed my concerns as expressed to Ron Lindsay. So what we have here, it's the print's a little hard to read, but what Bechtel did in this report is that they divided the project into I believe, 5 sections. So they look at the shield building, the containment area, the auxiliary building, the annex building, and the turbine building. Now, if I don't know if you've been shown photographs of the project, but the containment is basically an egg-shaped metal tank, except it's enormous. And it was done in multiple sections. The bottom is shaped like a salad dish, and then you put metal rings until you get to the right height, and then you put an upside-down salad dish on the top. That's your containment. Now, there's a lot of work in addition to just the metal, but that's the containment. And then the shield building is the concrete structure outside of that. And what this summary does is it took the high-level information from the Westinghouse schedule and showed what that schedule was projecting. And then it took the information that Bechtel had put together based upon these commodities that I talked about, earthwork, concrete, piping, and conduit and cable, and overlaid the two to compare them. So if we can pull out this first set of bars there down through the orange bar, yeah, that's good. Now that is focused on the shield building. Now there is a legend, and I'll walk you through the legend. See the black and okay, there we are. See the black and white is the contractor's critical path. So if we could drop the legend for a moment, you can see in the shield building, the contractor's critical path went through the shield building. And the bars in green are the subcomponents of the contractor's schedule. So this is a very high level schedule. I would really call this a level 1 schedule from the contractor. And what the contractor said is that the critical path went through the shield building, and you can see the orange line, which is Bechtel's projection. They agreed with the projected completion date by the contractor for what the contractor thought was the critical path. What I had hoped Bechtel would do, they would examine in more detail the contractor's schedule to determine whether it was realistic for the shield building to be scheduled that way. But instead, they found that the shield building had the same, would in fact have the same duration that the contractor was projecting in his schedule. So why did Bechtel conclude that the project would finish a lot later? It wasn't the shield building, which Westinghouse had said was the critical path. It was the other buildings. And what Bechtel told us, both on October 22nd and then in writing in the February report, was that the commodities in these other buildings were really going to take longer than the shield building. So perhaps I'm repeating myself, but Bechtel agreed concerning the shield building, which I was curious about. But then they disagreed on these others based upon commodities. But they didn't look at the various activities associated with each area. You can see they've got install large pipe, for instance, 10%, 70%, 90%, and they have a duration there. So that duration that they computed is based upon information that they got from the contractor as to the bulk quantities, and then they developed some projection about how long those should take, based upon Bechtel's own historical data, which must either date from the 1970s or 1980s or date from some project overseas. And they're projecting quantities, but they're not. That is not, to me, a critical path analysis. That's the type of analysis for which you don't need Primavera software. You don't need to be schooled in critical path methodology. All you're doing is taking quantities and a rate, and you're saying, well, for that quantity, for that rate, you need this many man hours, and we're going to put a ceiling on the number of man hours that you're going to be able to put in per week, and we're going to project out the time periods. Now, they probably did the best they could do with what they had. Given that they didn't download the Westinghouse schedule, given that they didn't have exact quantities from Westinghouse in those areas, that they didn't have the units that Westinghouse had used historically, achieved historically, didn't have the units that Westinghouse was projecting, that's probably the best they could do. So I'm not here to criticize the product that they produced in light of what they had. It's just that the methodology that they use and the information that they had and the time period in which they had to do it caused me to recommend to the client that schedule not be considered to be a valid evaluation of what was going on the project.
Chairman, I move that the project assessment report behind tab 13 be entered in the record as Exhibit 118, and that the schedule assessment report behind tab 14 be entered in the record as Exhibit 119.
Okay. They will be entered as Exhibit 118 and 119.
All right, Mr. Winnick, if you would, look at the document behind tab 15. You recognize this document?
I do.
What is it?
This is an email string between me and Martin Daw.
Who's Martin Daw?
Martin Daw, at this time, was in-house counsel for Bechtel. He is the person that I negotiated the original service agreement with, and he was the person who forwarded me the draft reports and the final reports, and so he was really my principal contact at Bechtel.
You say in your email dated February 9th, 2016, so this is after the date of the draft of the final report that we've just been looking at. You say, Martin, your email reminded me that I wanted to ask you about the health warning, in quotes, that I understood Bechtel was adding. I looked for it but did not find it. All that I noticed was a vague reference to what a more robust analysis could do. Did I miss something? Can you explain to the Commission what you're talking about there?
I can. Health warning, it was Martin's term. Martin's a Brit, although I guess he lives in the U.S. part of the time, and maybe they have different slang terms. But what he meant by health warning was, this is a preliminary report based upon complete information, should not, that sort of thing. And the reports that he sent me, the February reports that we just looked at, didn't contain anything in the bold letters right up front that I thought that he was going to provide. And you can see that he responds back, and he said that, you can see what he said. I just read the schedule report again, and it helpfully lays out in Section 3 all the assumptions that were made as part of the assessment. And then the conclusion in Section 4 is expressly stated to be based on the assumptions. So this seems to cover the waterfront anyway. So what I understood Martin to be saying was that he thought that the health warning was embedded in these assumptions, that anybody reading those assumptions would realize that this was preliminary and had limited use, and so I let it lay.
Mr. Chairman, I move that this document be entered into the record as the next hearing exhibit.
It will be entered as Exhibit number 120.
Who received the second schedule assessment report? That is the document that we marked as Exhibit 119.
Both of them were sent to me.
Did you provide the schedule assessment, that is the document we've marked as Exhibit 119, to the owners?
I did not.
Why did you not provide the schedule assessment report marked as Exhibit 119 to the owners?
Because that was the one aspect of the Bechtel product that I thought would be most damaging in litigation and served no purpose for the owner in understanding issues on the project. When I say served no purpose, I distinguish that from the information addressed in the project assessment. Now, the project assessment is 63 pages. So it addresses those 5 issues that I talked about in quite a bit of detail. And there was some interest on the part of the owner to take some of those items and use them in the ordinary course of business. Some of them they already knew about. Certainly the engineering issues were well known to the parties and were being identified by numbers in a log, and they were being cleared up as they were arising. So there was very little that Bechtel was adding on engineering. But on procurement, as I said, at least to me, the inventory management issue was new. Maybe it wasn't new to everybody at the owners, but for some of them. So there was some information, not all of it, but some information in the project assessment that could be beneficial to the owner as a manager of the project. The schedule portion didn't have that role. And to me, it was the part that could most be abused in case of litigation.
When you say damaging in litigation, what litigation are you referring to?
Well, again, the litigation in the Southern District of New York against Westinghouse.
What specifically was your concern about how the scheduling report might have been used by Westinghouse in future litigation?
Well, just as I determined or judged and recommended to the owner that we not change our deal with Westinghouse based upon the Bechtel assessment, I didn't want Westinghouse to later argue that we should have done that. We didn't change that deal because we didn't put stock in the preliminary Bechtel schedule assessment.
Did you continue to advise the owners about maintaining privilege over the assessment report?
I did.
What did you tell them?
Even with respect to the project assessment, I said that if you want to use any of these in the normal course, you should restrict the distribution and extract whatever points you think are important. But don't go around waving the Bechtel report and don't go around referring to it as the Bechtel recommendations. Extract the things that you think are useful to you in the ordinary course of business. To me, the predominant purpose was in anticipation of litigation, but there were some things that the owner thought would be useful in managing the project. I said, if you want to do that, just extract them from the report. Don't circulate the report widely. Don't refer to it as Bechtel recommendations. Just take the data, take the content, and use that.
In advising the owners to maintain the privilege over the report, was it ever in your mind that the report ought to be shielded from the Public Service Commission or the Office of Regulatory Staff? Was that ever part of your analysis?
No, I can't say enough times that never entered into my mind. I have no idea to what you folks are entitled to in terms of reports. Certainly when you ask for things, presumably there's an obligation to provide them. But in terms of things that should be provided that come along, I have no idea what the obligation is. And I wouldn't undertake to advise a client on those obligations. I wasn't asked to advise the client on those obligations. Had I been asked, I would have said, I'm not conversant with the issues. But I wasn't asked, and I didn't advise them.
Mr. Winnick, I want to finish this your direct testimony here by giving you the opportunity to respond to just a couple of the aspersions that have been cast upon you. We don't have time to go through all of them, unfortunately, but I want to at least give you a representative sampling and an opportunity to respond to them. Let's start with tab 16. Mr. Anthony James, a former ORS employee, testified in these proceedings in part that an attorney was hired to conceal the retention of Bechtel and Bechtel's reports. Do you have a response to that testimony?
I do.
What is it?
I have never interacted with an attorney who would do what an unnamed attorney, me, is being accused of doing, and you're certainly not looking at him. I would never do that. That's just not the way attorneys operate. I'll tell you that I first saw this testimony just a few days ago, and I've had a chance to read it and edit my thoughts because I don't want to overstate my response. But you know, you practice law for 43 years, and you're never accused of these things. And then somebody who really doesn't know what he's talking about, hasn't investigated the chronology, makes a statement like this, and then it gets picked up by the press, and it's out there, and well, I didn't expect that. I'm sorry, but that's not who I am. That's not who attorneys are. They don't get hired to conceal things. That's not what this was about. Again, the chronology here is that I had a concern about discoverability long before I knew of the Bechtel report. I'd been representing the owner since 2011 on a wide variety of issues. And Mr. Jones, I hope he will reflect on what his testimony was and maybe give second thought next time he's tempted to make these kinds of allegations based upon insufficient understanding of the facts.
Second allegation I want to direct your attention to and provide you the opportunity to respond to is behind tab 17. Gary Jones, a consultant for ORS on the project, in reference to Bechtel's schedule assessment, said the Bechtel report should have been embraced and acted upon as solid advice from an experienced and capable source, not ignored and hidden from the PSC and ORS. Do you have a response to that statement?
I do. I've explained my view of the Bechtel report and the advice that I gave to the owner at the time. Bechtel did perhaps as good a job as they could do on the schedule aspects, but they themselves recognized it wasn't robust enough to cause the owner to rely on it to change what the owner was doing, and the owner didn't rely on it.
Last, Mr. Winnick, I want to provide you the opportunity to respond to Mr. Jones's pre-filed testimony in this docket, where he said, this is behind tab 18, the Bechtel projected completion dates were a better approximation than anything developed by Westinghouse and are more in agreement with the dates that SCNG ultimately developed as part of their assessment of completing the project on their own during the so-called interim assessment period following the Westinghouse bankruptcy. Do you have a response to that?
Yes, I do.
What is it?
Nobody knows when this project would have finished because Westinghouse filed for bankruptcy. What we know is that Bechtel had a certain methodology and they did a projection. Was that projection right or wrong had the bankruptcy not interfered? I don't know. What I do know is that I evaluated that preliminary projection based upon methodologies. Whether they were right or wrong is not what I was after. I was after whether they could demonstrate that they were right or wrong. They might have been right by accident. They might have been, they just as likely could have been wrong. The methodology, though, I've tried to explain what I saw in that methodology and what I thought was flawed about it. Comparing it to some assessment that was done 2 years later, suggesting that somehow the Bechtel projection was anticipating those events that took place during those 2 years, and I don't think anybody anticipated that. Mr. Benjamin didn't anticipate the bankruptcy. I didn't anticipate the bankruptcy. Nobody was talking about the bankruptcy back in 2015 when Bechtel did their assessment. But as I understand it, the SCE&G projection was post-bankruptcy and based on the assumption that now it's going to be an owner-directed construction, which is a whole different kettle of fish. And again, I don't think Bechtel foresaw that, dreamt that it would happen. So they didn't dream the bankruptcy, they didn't dream the owner-directed efforts, they didn't dream any of those things. So I made my judgment, I've explained my judgment. You know what my judgment was back in 2015. I stand by that. I don't think any of this prepared testimony causes me to change that.
Mr. Chairman, those are all the questions I have for Mr. Winnick.
Okay, we'll continue on with cross. Mr. Guile.
Mr. Chairman, if I may, I'd like to defer to ORS to go first. There's more.
Okay. ORS. Mr. Richardson.
Thank you very much, Mr. Chairman. So much to go over. Let's just start with right at the end, when you took the position somewhat emotionally that the Bechtel assessment might have been right or might have been wrong, but that you had a problem with the methodology, and that's the reason why you unilaterally decided not to provide it to the owners, right?
My emotional response wasn't related to that issue. My emotional response was related to the personal attack against me as an unnamed lawyer who was hired to conceal. So let's be clear about that. Now, you have a question about my recommendation to the owner. My recommendation to the owner about the schedule assessment was that it was based upon an unreliable methodology, yes.
But you didn't actually make that recommendation. That wasn't my question. My question was, you're asking us to believe that you unilaterally decided not to even provide the schedule assessment report to the owners at all, so that they could decide whether there was follow-up needed to be done or not.
I think you're missing the fact of the owner's participation in the October 22nd oral presentation. They knew what Bechtel's schedule assessment was. It's just that was not put in writing, because writing tends to migrate, tends to travel, tends to get out. And I wanted to protect them in case of litigation from having that writing getting out.
But when you said that it might be right or it might be wrong, by not providing the written report of the schedule assessment to the owners, you were actually preventing them from doing any follow-up on that report at all, weren't you?
I didn't prevent anybody from doing anything.
Right. You didn't give it to them to protect them from something, didn't you?
I did not circulate a hard copy of the schedule assessment because I wanted to protect the owner in case of litigation in the Southern District of New York.
You're right. You advised your clients, though, that it would be just fine for them to extract the information from the program assessment report that you did provide them and to use that and still protect the report, didn't you?
I would have preferred not to have done that. But at a certain point, when the client simply directs that you provide them with the report, you do it. And so I did it. I did accompany that with recommendations so that report would have the greatest chance of continuing to be confidential. There would be limited distribution, and any use made of it would be through the method that I described.
But when the client asked you to give them the report, you didn't do that, did you?
You know what I did, and I'm not sure what you were referring to when you say the client asked you to give them the report. Can you point me to some request for that you're referring to, so I can understand what you think I didn't do?
Well, you gave them the program assessment report, didn't you?
Yeah, now we're going in circles, but yes.
And you didn't give them the schedule assessment report, did you?
I think that's clear.
And you follow the direction of your client, don't you?
Absolutely.
And if the client asked you to give them the report and you didn't give them one of the reports, it's because one of your clients asked you not to. Isn't that right?
No.
You're saying that you unilaterally, against the wishes of your client, withheld the schedule assessment report from them.
I think your question is false because it says against the wishes of the client. I made the edits that I made, and I believe that I was authorized to make those edits.
So basically, you knew best. You knew better than the owners, right? Who had the ultimate responsibility to the ratepayers, who had the ultimate responsibility to this commission and to the public, who were required and had promised to be completely transparent with the ratepayers in this commission. You knew better than to give them the schedule assessment report.
I believe they brought me in to give advice because they thought my advice was better than they would come up with on their own on a wide variety of issues. I guess I have to confess that I do think that the owners thought that I knew better on certain issues. Otherwise, my presence would have been pointless.
And you're taking a position today that Santee Cooper didn't ask you for that report?
I'm not taking positions. I'm relating what happened. And what happened is that I distributed the report when asked. Santee Cooper was aware that there was a separate schedule assessment report, and they did not ask me for that, ever.
Did they know
Yes.
there was a separate report?
Absolutely. There was an email from Martin Dodd that was sent to me and to Mike Baxley, and it says, I've now sent to George Wennick a copy of both reports, the schedule report and the project report.
And you didn't think that was important to share with the commission in your direct?
There are several hundred emails that we could have walked through with the commission about this, but you're the one who prompted the question, who prompted me to address that. You have that email and you obtained it in discovery. If you thought it was important to determine whether Santee Cooper knew of that report, it seems to me you might have brought forward that email.
Yeah, we're going to look at some emails this afternoon and test the credibility of some of your assertions. But what I want to get out is who you thought you were protecting by not providing them the schedule assessment report.
I'll say this again, and I'll say it as many times as you ask me, that I believed that I was protecting the owner group, Santee Cooper and SCANA, in the event of litigation with the contractor in the Southern District of New York concerning schedule-related issues.
And you first had a discussion about that schedule assessment that was in the November 12th final draft report. You had a discussion with Steve Byrne about that, didn't you?
I think I may have had discussions with a whole host of people, even prior to receiving the draft report, because my response to what Bechtel had done was immediate, and I wasn't shy about sharing it. and I shared it even before I got the draft report, as shown by my email to Ron Lindsay, because he asked me to flesh out my reasoning. So, yes, everybody knew what I thought of the schedule assessment. I think my whole reason for calling in was so that I could hear what Bechtel had to say and then share with the client my reaction and my advice concerning that report, and I did that.
And Steve Byrne was the first one to call Bechtel to tell him to take out the schedule assessment, wasn't he?
Not to my knowledge.
You didn't see that where he called him and gave him a heads up that you were going to be making changes to the draft report?
Nope.
You do know, though, that your client was supposed to be transparent and not filter information about the project given to the Public Service Commission and ratepayers and ORS?
See, now you're asking me to give a legal opinion, but I'll answer the question. I don't know what that obligation of transparency means when you get down to specific examples, especially down to this specific example. I don't know the answer to that.
And this is a pretty important example, isn't it, of a lawyer representing SC&G taking in front of this commission full credit and ultimate responsibility for SC&G not being transparent about the schedule assessment done by Bechtel. Isn't that right?
No.
You don't think that's a pretty big deal?
No, I don't think that everything you said in your question is right, so I can't assent to it.
And Mr. Balzer, you told him, you told the commission that you don't give legal advice in areas outside of your practice, and that disclosures to the PSC and the ORS were outside of your practice, right?
Correct.
But you gave legal advice to Carlette Walker about Baseload Review Act quarterly reports and making disclosures to ORS and the PSC in those quarterly reports. Do you remember that?
I remember being asked about certain items, limited items that were being provided to various parties as part of SCANA's disclosure obligation. And in general, what I remember is that advice was limited to the precise terms and implications of the October 2015 amendment. That's what I remember.
Let's look at the top of this email. Oh yeah, we need to set it up. I apologize. This need a little more of that. We'll identify which exhibit it is. It's already in evidence. Hearing exhibit 63. It's already in evidence.
Can I have a copy, please?
You see this email on November the 10th, 2014, from Kevin Marsh to Jimmy Addison and Carlette Walker about the Thursday meeting. And I believe the message to ORS should be that. You see, that's the topic of the discussion.
I'm sorry, Mr. Richardson. There are.
It's the third email down.
Third email down from whom?
Kevin
to
Marsh to Jimmy Addison, copying Carlette Walker. Subject line: Thursday meeting.
Yes, I see that. Thank you.
You see, I talked with Kenny this morning, and we believe the message to our ORS should be that we've had one initial meeting. These are ongoing, a report essentially to ORS about the ongoing negotiations. This is coming right after the consortium's EAC was provided in August of 2014.
I see. Do you have a question for me?
Yes, so if we go upstream from that email, we can see where your legal advice was redacted from this email. This is from Carlette Walker to Jimmy Addison. I also have the benefit of talking to George Winnick, redacted for privilege.
Yep.
See that?
I do.
Okay. All right. Let's look at another one. I get the Elmo. This is an email on November the 5th, 2015. From you, George Winnick, to Ron Lindsay about the BLRA quarterly report. See if we can zoom in. All right, there you go. And this is from you to Mr. Lindsay, talking about receiving your voicemail. And then you see the highlighted portion with respect to the BLRA filing, and then your legal advice to him is redacted for privilege. Do you see that?
I do.
And that was about what should go in filings to this commission, to the public under the BLRA.
That's it. November 5th, 2015, which is when the October 2015 amendment needed explaining.
Mm-hmm. Also, right after y'all learned about the Bechtel schedule assessment, wasn't it?
Well, it even refers to the Bechtel presentation, and I suspect that helps fill in a gap in my memory, actually, because I will write up my comments on the Bechtel presentation and send them to you. So that we saw that email that I sent to Ron Lindsay was dated November 12. So that at least gives you some additional context for that email.
And it shows that it's been redacted as your legal advice about BLRA disclosures, right?
Well, specifically about the filing on November 5th, 2015, when the October 2015 amendment was a hot topic. Let's just make sure that you're the lawyer for the SCNG, right? Who created the argument that was used not to disclose the reports, right? Well, I was a lawyer for SCNG and SCANA and Santee Cooper, and I made the recommendations about how to handle certain information from Bechtel based upon the way in which I'd set up the engagement from the get-go. And
you know that lawyer-directed vehicle delayed for 2 years the commission, ratepayers, and public from knowing that SCNG had this independent expert assessment of the project in 2015, don't you?
I don't know about the history of the disclosure. I occasionally read things in the newspaper, but I try not to be obsessive about it.
You know what you set up kept it from being disclosed to this commission, don't you?
I don't know when people decided that they had to disclose that. And if they thought they needed to disclose it, they had the oral information in October.
And that's because it really wasn't your unilateral decisions, was it, about what got disclosed to this commission? It was your clients, wasn't it?
So the client can always ignore my advice. It happens infrequently, but it happens.
So you're here trying to take these errors, but in fact, it was SC&G who made the decision about what and whether to disclose to this commission. Isn't that right?
If you're asking me whether my client could have ignored my advice, then the answer, I think, is obvious, but it's yes.
In fact, they've repeatedly taken a position in this hearing that the Bechtel report didn't provide them any new information and that they knew what was in the Bechtel report.
I have no idea what position they've taken in this proceeding. I've actually tried not to immerse myself in these facts because I wanted to just testify to the facts as I understood them and not have that testimony be colored by issues in this proceeding.
Seems helpful to you. But they knew what was in that schedule assessment report, didn't they?
Well, to the extent that they were paying attention on October 22nd, 2015, then they knew of the dates, they knew of the methodology, they certainly knew of the limitations, all of which was brought out by my questions during that presentation. So they knew that as October 22nd.
And not just the highlights that were in the preliminary presentation on the 22nd, but they actually received the draft report that you got November the 12th that had almost all of the language that was in the schedule assessment report, didn't they?
My memory's not clear on that. It's not clear to me whether the owner ever received from me or from Bechtel the November 12th draft that Bechtel sent to me.
They certainly asked you for it, didn't they?
Well, when you say they, understand that we had Scanna and Santee Cooper, and then there were a number of people that felt free to speak directly to me from both sides. So we're talking about maybe a dozen people. At various times, various individuals of those roughly a dozen people asked me to do things, and but didn't direct me to do things, didn't have authority to direct me to do things, and I didn't do things until there was a consensus, either that there was a consensus by the parties, or one of the parties says, I don't care what the other party does or says, do this, in which case I would have done it. But that's not the way these parties worked. They've been partners on Unit 1 and throughout the construction of Units 2 and 3, and I really never got direction from them unless it was consensus direction. I never had one party say, Scanna saying, do this, I don't care what Santee Cooper says, or Santee Cooper say, do this, I don't care what Scanna says. So occasionally I'd get an email from one of those dozen or so people that would ask me to do things, and then I'd seek clarification. I'd go up the chain at that company, I'd see what the other company thought, and ultimately what I did was what I understood those clients wanted me to do by their agreement.
What you just described was how you operated in this representation, right? Not the owners, not the clients.
No, that's exactly what they did. These are basically nice people. They deal with people in a courteous, respectful way. I never saw Scanna pull rank on Santee Cooper, even though they were the majority owner. They wanted to get along, and they wanted all decisions of any import to be made by consensus, and that's the way they proceeded. Certainly, in their dealings with me, that's the way they proceeded, and in their dealings with third parties that I observed, that's the way they proceeded.
You mentioned this. You know that SC&G was the controlling partner in the project and also had a limited agency agreement in which they could act on behalf of Santee Cooper on this project in certain areas, didn't you?
That's false. I knew that SCE&G was a majority partner. That part is true. Now, as to the limited agency, it was my understanding that every time SCANA or SCE&G acted in the role of agent, which was rare, they had to do it based upon a specific document. So there was a specific agency document issued when they signed the construction contract, for instance, the EPC contract. There's a recitation in the contract that says SCE&G by itself and as agent for Santee Cooper. It's my understanding that there was a separate document specifically giving them that limited authority. And when we executed the October 2015 amendment, there was again a separate agency agreement specifically authorizing SCE&G to exercise, to sign that amendment on behalf of the two of them, but it was limited to that. So if by your question you're trying to imply that there was some general authority of agency under which SCE&G could always act as the agent of Santee Cooper, that's contrary to my understanding and contradicted by what I know about the two times when SCE&G acted as the agent for Santee Cooper.
Simple answer to my question was yes. Isn't that right?
No, no. The answer to your question that would not mislead this panel is the answer that I gave.
When you got direct requests for these reports, in particular the draft report from one or two of the owners, you actually went and sought consensus, right? Isn't that how you actually put off Santee Cooper for over 2 months, providing them the draft report?
Your account of the events doesn't square with my memory. No.
But you described the fact that you waited for consensus to act, even in the face of a direct request for the report.
I never got direction to produce anything that I ignored. There were individuals who would say one thing one day and then say, oh, I talked to somebody else and never mind, and then they'd come back and ask again. That's kind of your life, especially when you're representing two parties. But anytime a party asked me for a document and said, I understand that there's an objection, but I'm authorized to ask for this and I'm directing you to produce it, I would have done it, but that never happened. We never got to that point. That's not the way we interacted. It was, I'm their attorney, for goodness sakes. It was not an adversarial relationship.
And the reason that you never got to that point of consensus was because Steve Byrne had a standing order for you not to release that draft report to Santee Cooper, didn't he?
He never ordered me not to release it, and I never learned of any order that he gave to anybody else to not release it. So I can't verify that.
But you never did it in the face of requests, did you? Because of this thing you keep talking about, I was never directed. Isn't that just lawyer speak for I'm trying to find a way to wiggle out of it? I want to hear the answer.
Rephrase that and let's
Thank
hear.
you, Mr. Chairman. Mr. Winnick, we all know you keep using this phrase, I wasn't directed to, even when you were requested to provide the report. Why is it that you felt like a direct request from the CEO of one of your clients wasn't also direction for you to comply with that request?
I don't, CEO of one of my clients, so you're talking about Lonnie or Kevin?
Both, actually, but either one works for the...
If you think that they gave me a request that I ignored, please show me the request. Because I don't recall ever ignoring a request by either one of them.
Make sure you stay close to that mic. They can't hear you in the back. Sorry.
Mr. Winnick, did you ever provide the draft report to either Kevin Marsh or to Mr. Lonnie Carter?
I don't think that I did.
Mr. Winnick, before you ever got involved in the Bechtel assessment issue, SC&G and Santee Cooper's, both management and boards, had already agreed to hire Bechtel for the assessment, hadn't they?
If you mean, did they enter into a binding agreement? No. If you mean that they had decided to go forward in that direction, that's apparent. That's why they authorized me to then formalize that engagement.
And their boards had actually approved the hiring of Bechtel before you were ever asked the first question about this assessment. Isn't that right?
I have no knowledge of that one way or the other.
And when you first heard about this assessment in late May, we saw your advice and counsel was to make sure that you papered the hiring to shield the assessment report from litigation. Isn't that
I
right?
didn't paper anything, and I didn't shield anything. What I did was I responded to a request by Al Bynum in which he raised the concern of creating discoverable information. And I then followed my standard practice and advised Al that I recommended it. I didn't follow my standard practice yet. I advised Al that I thought we should follow my standard practice under which I would engage them.
Right. You told us you got your personal service agreement and you finalized that around August 6th, 2015, to say that your law firm was hiring Bechtel primarily in anticipation of litigation with Westinghouse, didn't you?
Yes, that's a fair summary.
But that wasn't true, was it?
That was absolutely true.
It was true for your primary purpose. You told us about that, but I mean, it wasn't true for the owners, was it?
I don't know why you think the owner had some separate agenda, separate and apart from the legal agreement that they authorized me to enter into. When they authorized me to enter into a legal agreement that says what that agreement says, I understood that they shared my viewpoint and that they understood that I was engaging Bechtel for that purpose. There had been some back and forth with Mike Baxley, and we've seen some of that about whether to engage them in anticipation of litigation or not. And I was authorized to go forward with the agreement that I used.
All right, let's go back to the computer, please. Let's look at quickly at your first involvement with hiring Bechtel, that May 22nd, 2015 email. You probably recall, if we can see it or not, but you probably recall it said that we need to establish we're hiring in anticipation of litigation. Do you remember using that language?
Well, I'm looking at Exhibit 106, which was offered today.
May 22nd, 2015 email?
And it says, to do that, we need to establish that we are hiring Bechtel in anticipation of litigation.
That was my question, didn't it? Don't you remember using the words, we need to establish we are hiring in anticipation of litigation? Do you remember that?
It says that right there.
It says that. And in order to create the in anticipation of litigation for the Bechtel hiring, you actually had to first convince SC&G and Santee Cooper and then Bechtel to change the previously stated purpose of the assessment, didn't you?
Let me see. Let's take them one at a time. Otherwise, it's going to be just confusing for me and perhaps others. There was an email that we saw where Mike Baxley was concerned about engaging Bechtel for that purpose because he thought that it would undermine the openness of the consortium, that is, of the contractor, as part of the assessment. And we saw that was his concern. We saw those emails, and I wrote back and explained why I didn't think that would be a problem. And then we saw how that problem, imagined problem, was addressed, where the contractor expressly agreed that the purpose of the assessment was to give advice to counsel. So That I think explains the client. And then as to Bechtel, I sent the draft agreement to Martin Daw, the attorney for Bechtel, the PSA agreement, and he didn't require convincing. He came back and tweaked some of the language, primarily concerning payment, and then we agreed on a draft and executed it. So you can call that convincing if you want, but there was not real resistance to that, as I understood it.
Well, you got SC&D to make a condition of Bechtel's hiring that they sign the personal service agreement that you presented to them, didn't you?
That's not the way I would put it. Certainly, Bechtel was going to want an agreement, a formal contract with somebody before they were going to do $1 million worth of work. And it was agreed that somebody would be my firm.
There was already a proposal and a discussion of purchase orders in order to affect that hiring before you ever got involved, wasn't it?
Well, I know there was a proposal because that was attached to Al Bynum's email, which is Exhibit 106, and I had certain objections to that proposal because that would not serve my needs, and that language was changed.
And it was your needs, and as you testified, your primary purpose, and that your typical approach by attorneys, by lawyers, and by you in retaining experts. But in this situation, the owners were wanting to assess the project and schedule and how to get the project constructed. Isn't that right?
In May, when I received Al's email telling me about Bechtel, I thought that this was implementing my recommendation from the previous year that it would be useful to me to bring on a scheduler and an accountant type and perhaps some other experts in order to evaluate the case, because it seemed like we were headed to litigation in the short term. So I think people were hoping that Bechtel would serve a dual purpose, but it's clear that under the terms of their engagement that everybody signed off on, that they were to primarily be working for me, assist me in evaluating the job, and it was in anticipation by me and by the client of litigation.
That's what the agreement said.
That's the agreement. And no one ever said to me or intimated to me that they thought that was a sham. And if they thought it was a sham, I mean, if you're contending that everybody involved with that thought it was a sham, you're slandering a lot of people. Because the people, everybody signed off on the personal service agreement. Everybody signed off on the confidentiality agreement that the owners signed. So you're alleging a lot of people were in on some sort of conspiracy that really is not supported by the facts, and it just isn't plausible.
I'm absolutely saying that, and
I know you are.
You papered the deal to try and put it into this framework that you think is just typical for lawyers, but that's not how.
Mr. Richardson, we're going to stop right here. We've got to. I've overextended a few people.
No problem.
So we've got. Want to remind everyone we have a commission meeting at 2:00, and we will start this back as close to 2:30 as we can as soon as we get finished with the commission meeting.
And Mr. Chairman, can we just please remind the witness who hadn't been here that not to talk about his testimony with anyone while we're on?
We'll remind it.